Everyone, this is Frances Caballo, and I am so excited because today we have Helen Sedwick. Helen, hello.
Hi there.
I'm so happy. Helen is a great lawyer, so I'm going to read her bio, and then we're going to get right into the presentation because that's what you're here for. So Helen is an author and business lawyer with 30 years of experience. When Helen published Coyote Wins, she realized there was no legal guide to helping self-publishing writers deal with wide-ranging issues such as copyright, defamation, and taxes. Helen wrote the Self-Publisher Legal Handbook to help writers publish and promote their work while minimizing legal risks, which is a really good topic. And that book has done very well, hasn't it, Helen?
It has. And today I've come out with the second edition, which I'll show you the cover here. It's now available. And what this edition does is it covers many of the same topics, sometimes in a different way because different people understand or learn things in different ways. But then from hearing from writers, I realized there were some more topics to cover that I hadn't covered in the first edition, such as using pen names, or people wanted more information about writing memoir, the legal issues of writing memoir, and using family photos and family letters. And even there were some questions about estate planning. So this new version's been updated and expanded to cover more topics.
Great.
And it just came out today. So, but the other one has sold pretty consistently now for 3 years. So, and that's been it's great because it's nice to have your book sell, but it's nice to know that there are a lot of writers out there who want to really get their arms around these issues and be in control of these issues rather than these issues coming as a surprise to them when things go wrong.
Right, and I was just telling Helen before the broadcast that I ran into a minor legal issue with the title of a book, and I had to take the book off of sales on Amazon. And so you never know when a legal issue is going to arise with your writing, and so this book is really important to have, and I encourage all of you to go out and get it for a friend as well, because, like I said, you just never know when a legal issue will crop up with the title of your book or the contents of your book. So,
and also it covers this basic business setup, because for many self-publishers, they're surprised that they're starting a small business, and most of us have never done that before. So it's some of the really nitty-gritty about registering your company, whether you should be incorporated, some basic tax things. I cover those as well.
Wow, that's really true. Yeah, because when you're writing a book and you're self-publishing a book, you are a business.
You are, and that's a new way of new thinking for writers, because they're thinking as artists, not as business people.
Right. So, are you ready for the presentation?
I am.
Okay, so we're going to go off. You won't be able to see our faces anymore, but you'll see the presentation, and then you can ask questions. And throughout the broadcast, we can ask Helen I can tell Helen what your questions are, so don't be shy. Okay, I'm going to go on.
How do people ask questions? Do they type them in?
Yeah.
There's a box?
They type them in
the
chat box. And then, Helen, do you want me to interrupt you, or do you want to pause every certain number of minutes, or?
I'll pause, because there'll be certain points where it makes sense to pause and see if there are questions. So.
Okay.
Okay, I'm going to get this started now. I'm going to change presenters. Okay, now.
So everybody can see the presentation, right? If you can't, let us know.
Okay.
Just type a message in the chat.
Okay. Yes, it should say protecting your rights in your wallet on the page right now. I'm going to start off the talk with some basic nuts and bolts information about what you own when you create a written text, and what the basically attributes of copyright are, because then I'm going to transition so that you understand how to protect those rights and not how to unintentionally step on the rights of others, because we all want to respect each other's rights. So let's start let's assume that you have your manuscript on a little flash drive. It's something that costs about $4. At this point, you don't know whether your manuscript is worth the $4 that little disc is that you paid for that little disc, or $1 million. But what you do have is you do have something you do own a piece of property. It's called intellectual property. A fancy word which just means legally it distinguishes a product of the mind from a product of the hands. And you can protect intellectual property just as you would protect your car or your home. So what I'm going to talk about today is maintaining control over that property, because there's this tension in when you do your writing. In order to get it out into the world and into readers' hands, you're going to have to give up some of that control to others, but you don't want to give up more control than you have to. Again, you're going to control who uses your work, just like who can drive your car or live in your home. Because there are people out there and companies out there that will try to take that control from you. For instance, one of the worst are some of these enter your book in a contest or your story in a contest and win a prize. Because some of these companies, you enter their contest and the prize is they get the right to publish your work in all formats, all languages, film rights, merchandising rights, etc. And they get to do this without ever having the opportunity to negotiate your contract or get an advance. So a lot of contests are really overreaching. And then there are some companies that you get involved and they publish your book either by self-publishing it for you or because they're a small publisher, and they have what I call our sticky fingers, which is that if things don't work out, it's really hard to get your rights back. So these are the kinds of nightmare scenarios that I want to help people avoid. So what is it that you own when you create a story or a piece of written work? You own what's called a copyright. Now, a copyright attaches as soon as you put your work into tangible form, whether that's a notepad or a computer hard drive or soft drive or whatever. It doesn't matter if it has cliches or typos. As soon as you put it in a tangible form, you own the copyright in it. Now, it used to be the copyright wasn't really valid unless you put a copyright notice on it and registered it and published it, but that's no longer the case. Since the 1970s and then in the 80s, it went further. The copyright attaches automatically. And it lasts for a very long time. It lasts for your lifetime plus 70 years. There are some other nuances if you happen to be working for a corporation, but I'm going to assume everyone listening today is an individual. So if you publish something today and live another 40 years, the copyright could last 110 years. So your grandchildren and great-grandchildren could be earning royalties. You've heard about a copyright notice. As I said, it's not required, but it's always a very good idea to use it. It kind of puts people on notice that it's your work. And it also means that if somebody wants to track down who wrote a particular blog piece or short story, it makes it much easier for them to find you. Now, many people say they copyrighted their work. That's kind of a misnomer. Usually what they mean is they registered the copyright to their work. This is an additional step. It is not required. You will still own the copyright in your work, even if you never register it. But registering the work does make sense. You can't bring an infringement action unless you register your work. If you register it promptly, after publication, you can recover attorney's fees, and you get what are called statutory damages, where like an automatic award of damages without having to prove lost sales, which can be a very difficult thing to do. You can even register blogs and websites. Many people they probably will never sue anybody for infringement because it's never going to be worth it. But for many people, they actually feel much more comfortable and much safer having registered their work. And it's very inexpensive. You can do it for $35 and do it online. So what's protected by copyright? Obviously your manuscript, books, poems, things that are in writing, blog posts, images, films, movies, songs, musical notations, and architectural works. But what's not protected by copyright is actually the interesting question. Your ideas, your basic idea of a story, unfortunately, is not protected by copyright. So if you've got some clever premise, like you've got a superhero with a brand new idea of what the superpowers she has, or a particular new way to murder somebody, or some other idea like that, that's not going to be protectable, and this kind of drives writers crazy. What is protectable is if you take that idea and you turn it into something more than just an idea. It's a story. It's how you tell the story, how you structure it, your unique characters, your unique settings. But the idea itself is not. Also not protected by copyright are factual events, historical events. John Steinbeck is not the only person who can write about the Dust Bowl. I've written about the Dust Bowl, and others have too. So just because somebody has written about a particular historical event doesn't mean they have the exclusive right to do it. You may also explore these historical events and use historical people and historical facts in your story. Nobody will own that, even if they write about it. Also not protected are stereotypical characters like the gangster, or the handsome but dull hero, or the damsel in distress, or the evil alien inside someone's body. So those kinds of ideas, you can't protect it if you're using it, but it also means someone else can't stop you from using it. And then another category of work that's generally not protected by copyright and can be used is short phrases. The internet's covered with short phrases. This is a bit ironic if you think about it, because writing something that's both powerful and short is, I think, the hardest thing to do. But the copyright law doesn't want to lock up words or phrases by giving people the right to protect short phrases. The one exception would be lyrics. Whenever I go to conferences and I speak, I usually raise the question, say, how many people are using lyrics in their books? And about half the people in the room will raise their hand. Lyrics are a great shorthand way of communicating setting, your characters' tastes, and maybe even social classes. But what happens with lyrics is they're not owned by the artist. They're usually owned by a music company, and they can be very aggressive about trying to extract as much money as they can out of their lyrics. So if you're going to use lyrics, you do need to investigate whether you can get permission to use them if they're really a significant piece of your book. However, you may use the title of a song, and you may use the name of the artist. Neither of those are protected and covered by copyright. So that's going to talk about copyright. So now, when you own a copyright, now you own this thing. How do you get it out there in the world? How do you grant somebody else the right to publish it? So to talk about then a little bit about publishing contracts, I'm going to start with some vocabulary. But I think this is probably a good time for a pause before I get into actually, now we've got the concept of copyright and how does it apply. Are there any questions at this point?
No questions so far, Helen.
Okay. So
oh,
now
yes, there is. No, there is a question. There are two questions.
Okay.
Michelle has asked, can a Canadian indie writer register a work in the United States?
Yes. People outside the United States may register their work in the United States. It's a great way to create a permanent record of what your work looked like on a certain day. Also, if you want to sue anybody in the United States, you'd have to have it registered. So a lot of countries don't have a registration scheme. For instance, I know in England, you can pay somebody, a private company that, quote, registers your work in order to create a permanent record. But those companies, they're like $200 to register your work, and then it's another $75 a year. If you register it in the United States, it's a one-time $35 charge, and it lasts your lifetime plus 70 years. So that's a great question. I'm glad Michelle asked that.
And then she has a comment that copyright in Canada is life plus 50 years.
That's true. In some countries, it's 50 years. In others, it's 70. That is correct. And your copyright law that applies is the law in where the work was created. And for most of us, that's where we live, is where we work. It may also be where it was first published, but let's say where it's first created. Most countries recognize, have signed on to treaties where they recognize each other's copyright. So if somebody were to take my books and then publish them in France, I could bring a legal action in France to stop them, and the French courts would recognize my U.S. copyright.
And Suzanne Sherman has a question. She asks, where do you register your copyright for $35?
The U.S. Copyright Office. Go directly to the U.S. Copyright Office, and it'll be $35. If you search U.S. Copyright Office, you're going to get all these companies that are going to offer to register it for you, and they're going to charge you a couple $100. Not necessary. It's really easy to do it on your own. The U.S. Copyright Office also has a YouTube tutorial that will walk you through what lines to fill out on the online form. So go directly to the U.S. Copyright Office. And if you go to my website under resources, I have links right to that site.
Oh, that's wonderful.
And in fact, most of the time when I talk about places to go to my website, HELENSEDWICK.com, and you click on resources, and down the page you'll see links to all kinds of helpful governmental sites and other sites. Okay?
Great. I think that's the last question for now.
Okay, so now you've got a story, you've got a book, and what are you going to do with it? So now let's say you're going to try to go through the traditional publishing route, and you're going to try to get a contract. So here's some language that you need to know in order to look at a contract without it seeming like, as I will say, I'll repeat this line, it's 5,000 words run through a blender. No, there are ways to look through a contract. But here's some vocabulary. First, I'm going to skip to license. What you generally are giving is a license to somebody, which merely is permission to publish your book, and then you add parameters to that, certain countries, certain languages, certain formats. That permission might be exclusive, meaning they're the only ones that can print it, or it might be non-exclusive. For instance, if you're self-publishing, you are going to let Amazon sell your book, and also Ingram Spark sell your book, Smashwords, non-exclusive. People can do it at the same time. Actually, an assignment of rights, an absolute transfer of rights, is rare. It really should only come up in a ghostwriting situation. So if you see somebody asking you to assign all your rights, run away. Another terminology is reversion. When do your rights come back to you? This is a traditional publishing concept, not self-publishing. Self-publishing, you keep your rights. But if you go with a traditional publisher, when and how do they come back to you? If sales drop below a certain threshold, after a certain number of years, certainly if the company goes out of business. And then the other term is subsidiary rights, which is a bundle of rights such as movies, plays, merchandise, and translations. The way I like to describe this is if you have a book, think of it as owning an apartment building, and you've got a lot of little apartments. One apartment might be ebooks in Spanish. Another apartment might be print books in Chinese. So what you want to do when you're talking to publishers is you want to give a publisher rights to only what that publisher actually can use. If they only publish English books in Canada, then that's all you would really want to give them. You don't want to also give them audio books in Spanish because they don't have the capacity to do it. There's no synergy there. Think of it about that you want a relationship with a publisher or a film producer where you both make money. If the publisher can't take care of a certain market, reach a certain market, then there's no reason to give them those rights. You certainly don't want to give them the entire apartment building if all they do is do acts in Chinese. And I hate to say this, but there are contracts that say that will have those kind of rights, and I'll show you some samples. So how do you know what these contracts say? You're going to have to read them. And yes, these contracts do look like, as I said, 5,000 words run through a blender. So the trick is you don't start at the beginning of the contract. If you do that, by the time you get to the important stuff, you're going to have got into this faded state where you won't be absorbing anything. So even I start with a contract. I start with what I look for the grant of rights. Where are you granting the license? Where are they talking about ownership? And I'll give you some examples of the kind of thing to look for and the kind of thing to run away from. You also want to look how to get out of a contract. Not every contract is successful. In fact, many are not. So you want to know how to get out of it. And you don't have to go it alone. You can work with an agent or an attorney or do your homework or do some seminars. Try not to be intimidated by these contracts. So before I get to any examples, I just want to make one big distinction here between traditional publishing and self-publishing because this distinction is getting blurred in the market. A traditional publisher will pay for editing, design, printing, and promotion. A self-publishing company, the author pays for this. There are many companies out there that call themselves publishers. In fact, they may even ask you to submit your work and they, quote, accept it. But as soon as they ask you to take out your credit card and give it to them in order to pay for editing costs or any other costs, you're dealing with a self-publishing service company, not a traditional publisher. I have no problem working with self-publishing service companies. I work with them. That's how I self-publish my book. But I do have a problem with self-publishing service companies that try to pretend to be traditional publishers. I think that's confusing and it's not to the writer's benefit. And then there are companies out there that are called hybrid, where both the author and publisher invest money. Each one seems to be a little bit different. I personally think your dollar will go further if you do the self-publishing yourself and not share it with a hybrid publisher. It really depends upon your time and money in your life, whether you have more time than money or more money than time, then you could make these decisions. So let's look at what you don't want to sign. Author Solutions is a bunch of companies. I think there are about 10 different companies under this umbrella. And they have a terrible reputation, and it's deserved, I believe. This is and they're a self-publishing company. So they are working for you. You would hire them to do editing and book production and distribution and some marketing. But you are the publisher, and you should be able to hire and fire them at will. Yet, this is what their contract says, that throughout the term of this agreement, you give them exclusive, transferable, worldwide rights, and I'm going to skim to this, in all distribution channels, in all languages, print, digital, audio, or any other medium, even if it doesn't exist today. And I have to tell you that I have helped Author Solutions used to have this contract where it was very hard to get out of it. Now you can actually give them notice and get out of it. But I've worked with authors where it's been a year since they tried to terminate their contract with Author Solution, and Author Solution is still selling their book. So this is a very troubling contract. And then here's a contract from a contest where, again, you submitted your work, you're getting no advance, and this company just does apps. So all they're doing is taking children's books, in this case, and turning them into apps that kids can look at on their tablets. Yet, merely by submitting your work to this contest, you're giving them exclusive worldwide perpetual rights in print, audio, sound, digital, in all languages. And then it goes on to say that they can write prequels and sequels, and they can develop merchandise, and they can sell film and TV rights to your work. And this is all just because you enter their contest. Now, they'll give you a royalty, but it's not like you're going to have any opportunity to negotiate that royalty. It is whatever it is. And most people will enter this contest with great excitement without looking at the fine print. So I want to emphasize that you own something. You need to be smart about protecting it, just like you would lock up your bicycle or something else that was really important to you. And that while authors fear that someone's going to steal their work if they post it on their blog, you're much more likely to lose your work by signing a bad contract. So do take the time to read those important provisions of the contract, go right for them. If they're bad, you don't need to read the rest. And if you're not sure, reach out for help. There are a lot of resources out there to help you. It's available. There's California Lawyers for the Arts, and a lot of states have those. There are a lot of author writers who are blogging, who will take comments and questions through their email. I do it when I have time, but don't try to do it alone. I'm going to transition now to talk about using work created by other people. So this is probably another good time if there are any questions.
So far, there aren't any questions, any new questions.
Okay. And if anybody wants my slides, because these things are going by and you want to keep these samples, just email me at helen@helensedwick.com, and I'll send you the slides. Okay, now let's talk about using work created by other people. So if you see, here's a question for people, which I'll answer, but the question is, if you see a cute kitten photo on the internet, can you cut and paste it and put it on your blog or put it on the cover of your book? The answer is, well, no. It's not a safe thing to do legally. You really don't know whether somebody is claiming ownership of that cute kitten photo. As if you recall, when I talked about copyright, you don't have to, a copyright can attach even if the photographer never put a copyright notice on the image, and that publication and registration is no longer required. This is the downside of things being simpler. Stuff that's posted on the internet is probably owned by somebody. So, and in fact, it often with like the cute kitten photos, what often can happen is people post them on their website, and there are companies out there, stock image companies, that own tens of millions of images. They use service companies that search the internet for the images that they own. And if they find their images online, they'll see whether whoever's using it has bought the right to use this stock image. And if they don't find it, and they're not very diligent in their search, they will send you a letter demanding anywhere between $1,000 and $2,000 because you use their image on your blog post. It would be even worse if it were on the cover of your book. So, your blog post, you can go and you can take it off. But if you book and you've put it up there and it's on Amazon and you have a box of 500 of them in your garage, you really don't want to suddenly not be able to use that kitten image on your book. So you do need to be sensitive to whether an image is owned by somebody else. Giving credit, people say, well, I gave credit. If so you know who used it and you give credit. Credit is not enough. People own that image and you need to get permission to use it, and sometimes you need to pay to use it if it's that important. You can search images on the internet just like you search text. And I'll give a brief description of that. If you have an image and you really want to use it and you have no idea where it came from, you go to your internet and put a search for Google Images, and you'll get click on that and you'll get a search box, just as if you were typing in text. And you'll click, there'll be an icon there of a camera. If you click on that, you can either upload the image or upload a URL to the image, and then Google will search the internet for that image. If you see that image is showing up and it's on a stock image site, then you really have to go to that stock image site and buy the license to use it. It may be $5, maybe $15, but at least you'll do it and you'll reduce that risk. What often happens is the image will be used in 300 different places, and you can't figure out who owns it because everybody's using it. And I get these questions from people all the time. In that case, it's probably low risk that anybody's complaining because it's been out there, but there's still some risk that somebody might own it. And then not on images, but remember about lyrics that you can use the song or a book title or the author's name or songwriter's name without permission. Now, what are some sources for images and text other than the internet? You can look for works in the public domain. That's a whole nother article, and on my blog I talk about some of these things. But generally, a very old image, or old text, anything that was first published before 1923 is in the public domain. The copyright has expired. So if you want to do a rewrite of Pride and Prejudice or any Shakespeare play, that's fine. You can do that. Those materials are all in the public domain. There's something called a Creative Commons license, which is people can decide to let others copy their work, and they put an insignia on their work saying it's a Creative Commons license. Like Wikipedia, a lot of its text is people have basically said you have permission to use it regardless of the copyright. So that's another avenue. Or you go to the stock image and music companies and you purchase the right to use a particular image in a particular way. Again, it's usually very reasonable. You can also track down the copyright holder and ask permission. And then finally, there's this notion of fair use, or in Europe it's called fair dealing, that if you're using work created by others for education, commentary, criticism, or parody, that is not considered a copyright infringement. That's considered basically a whole new use and discussion of the work. Now, fair use is a defense. You would have the burden of proving that your use was fair use. But if you're really using it, basically you're taking the lyrics of Bob Dylan and Eminem and you're comparing their treatment of women. That's probably fair use. But just using their lyrics to kind of create the setting to take your characters into, a smoky love-in in the 60s, that's not fair use. That's really piggybacking on the creative talents of the original artist. In terms of using images and lyrics, I've created 2 downloads that are free on my website, and they're also for 99 cents on Amazon, but they're free on my website because I get so many questions on just the mechanics of how do you figure out, do I need to get permission? How do I get permission? What do I ask? Who do I ask? So I have these downloads that are available to help walk you through that process. Lastly, I'm going to talk a little bit about scams and myths that are your inbox is going to be flooded with, but this is probably another good time for questions about using work.
We have several questions.
Great.
So Suzanne asks, can you use a few lines of song lyrics in a book manuscript without infringement?
Technically, it's infringement. So, you know, if it's fewer than 15 words in a song that has a lot of words in it, it's probably too small for anyone to care about. If you're using 15 words in a song that only has like 20 unique words in it, that makes it, you're using more of the whole, and so it's a little bit more problematic. I'm kind of getting into the area here of risk. You know, how much risk do you want to take? If it's really important to your book, like, it's not just, you're not just setting a scene, but one author, listening to particular lyrics was a moment of revelation and redemption for this character. So this author really wanted to use these lyrics. And they were key, and they were a focal point in the book. If your use is rising to that level, then you'll sleep better and you'll have much less risk if you go through the process of getting permission. It's a risk that someone's going to find out and not like it, and they're going to send you a lawyer letter.
Okay.
Any other questions?
Yeah, Rosemary, oh yeah, quite a few. Rosemary Letson asks, what about if you post an image on Facebook or Twitter or Instagram?
If you're posting it and you're just saying, isn't this a cool image, or you're saying something about the image, and you're linking back to the original source, I think that's a low-risk use, and Instagram is full of that. If you're using it in a way that kind of promotes yourself, or let's say promotes your own blog, you're using it as an attention-grabbing device to direct somebody to your material, I'm less comfortable with that. I think that could be considered an infringement. Again, what you're doing, instead of kind of highlighting this beautiful quilt or something, this beautiful photograph, you're using it to hook people into your work. That is what will get you into trouble. So you have to look at not only the work itself, but how you're using it.
Okay. Michelle notes that on Shutterstock, you can buy around 5 images for $50, which is a lower tier license. So that's always and Deposit Photos is another place where you can go and buy photos.
Yes, Dreams Time, iStock Photo, Getty Images. And there are many of them that are claimed to be free. Those make me a little nervous because, like iStock Photo or Dreams Time or any Getty Images, they say to you, you buy this from us and we guarantee that you have the right to use it. The free download places say, well, we think you have the right to use this. We're not real sure. And if you get into trouble, it's not our fault. So for something as important as your book cover or your web page that you're getting designed, I would pay the $10, to get an image. It's such a easy risk to avoid. So just do it. Just pay the $10 and then not worry about it again.
Okay, and Michelle asks, can you introvert the words of an existing popular book title for your own book title?
One issue about book titles is if they become really famous, such as the 4 Dummies series or the Harry Potter series, they're protected by trademark law as opposed to copyright law. A trademark is a concept that it identifies a particular good or service in the market. So if the name that you're playing with is an identifiable trademark and you're kind of wanting people to recognize that trademark, you may get a letter from the trademark owner asking you to stop doing that. You're unlikely to actually get sued for it. You're going to get a letter asking for it. You'll get sued for it if you're actually really faking, selling Gucci products when they're not Gucci products. There is one exception if you're really making fun of something. Like if you were to sell a book, say, Martha Stewart-like recipes, that's probably trademark infringement. But if you wrote a book and you titled it Martha Stewart, Get Out of My Kitchen, that one might be considered a parody and perfectly fine. Getting into legal hair splitting, but in the law, it's not just what you're using, but how you're using it that you need to think about. And it's kind of a fun little puzzle. So that's a long answer to a short question. Sorry about that.
Oh, that's good. Okay, another question from Michelle. Something like that, a fun pun, thanks.
A fun pun, you're probably fine. And the thing that you're risking is you might get a letter from the trademark owner asking you to stop. It might be from a lawyer. It might even be a little chest pounding. In which case, you can make a decision then to stop. The lawyer letters, that's what they're there for. They're to tell you to stop, and many people are perfectly fine just taking the risk that, okay, they tell me to stop, I'll stop then, but until then, I'm just going to do it. So that's going to be a personal decision on your own tolerance of risk.
So as a follow-up comment, she said cease and desist.
Yes, that's the kind of letter. It's a cease and desist letter, yes. I call them lawyer letters or nasty lawyer letters. Yeah, that's the magic words that they'll say. Cease and desist, using my client's trademark in a disparaging way or something along those lines.
All right, that was the last comment.
Okay. So let's take a look at some of the scams that will flood your inbox. One of them I talked about, some of these are not scams. Some of these are myths. Some of these are people are trying to sell you some service or some app or something that they say is the secret to having a best-selling book. And most of us have put so much work in our books and have maybe spent a lot of money on editing and copy editing, that the thought that maybe for $99 or $999 we can hit the bestsellers list, we're tempted. It's tempting because you think maybe somebody knows something. So you have to look at these offers with a skeptical eye. Some services are worth paying for, most are not, and of course just be sensitive. The more you're paying, the more you need to really consider it, because again we get back to the big question of risk. Some of these are so-called selective presses that are really self-publishing companies. I mentioned that earlier. They use the acceptance of your work and flattery to try and loosen your wallet, so be cautious about those. You'll get invitations, again, that say they're very selective to have your book presented, be on a table at a book fair, the Frankfurt Book Fair, for a mere $1,000. Usually those are way overpriced. If you really want to have your book on a table at the Frankfurt Book Fair, team up with a bunch of other authors, and you can probably accomplish the same thing much more cheaply by doing it directly. The Hollywood pitch experts are out there. I recently had somebody who was helping, if you want help getting her father out of one of these things, where the company had sold him $30,000 worth of Hollywood pitch services and hadn't done a thing. It just was frightening. The offer to be put on a hot list. I get these emails because I've written a middle grade novel. I get this email once a year from this company that puts me on the hot list for authors who will do book tours, and it would cost me $3,500 to be on that list. Kind of silly, because I could never speak to enough schools to make that money back. Media packages where someone offers to interview you for a radio show or a blog post or something. which is great. You should do that. But if they say, oh, but we won't advertise it or let anybody know we have this interview unless you pay $500 or $399, just be cautious of whether the money is worth it. Some contests take too many rights away from you. I think there are many, many legitimate contests that you absolutely should consider joining. The shorthand way to try to figure out whether a contest makes sense is you go to Goodreads. Goodreads has a page called Award or Awards, and they list books they look at all kinds of awards. I think they have thousands of different awards by genre, by language, by region. And so those awards have some prestige. Those contests have prestige. If you are thinking of a contest and it's not on that Goodreads list, then it probably doesn't have much prestige, and it's probably not worth the $75 or $150 entry fee. Some of these contests are merely just cash-generating machines because they'll get 10,000 entries at $100 each, and that's a lot of money. Fake self-help sites. This is common in a lot of industries. Like you want to buy tires, and you'll go to a site and you'll look at tires, and it ends up that site's owned by Firestone, and so every tire they recommend is owned by Firestone. There are companies like Author Solutions that have those kind of self-help sites. It's like print your book, publishyourbook.com. No matter what you put in there, you're going to get an Author Solution company. And then any company that doesn't have all their information on the website, that makes you talk to a salesperson, those make me nervous because some of those salespeople are very aggressive. These are some of the bogus self-help sites. Let's see, contests. These are some of the things to look at, the sponsor, the fees, whether there's, if it's the Green Book Festival and you search for Green Book Festival and there are no pictures, you wonder, what kind of prestige is there? There are also websites out there where you can search for these companies or post whether anyone's ever heard of them. There are a lot of actually groups now in Facebook where I regularly see people say, hey, I got a solicitation from XYZ company. Anyone know anything about them? So again, you don't have to go alone. Because one thing that's really, I think, very extraordinary about the self-publishing or the writer community, even the larger community, is although we are all technically competitors, we don't act like it. If you post a question on Facebook or a forum about an XYZ company or about character development or layout, you're going to get 25 people giving you responses. It's a great network of people out there. So it's an extraordinary community to be part of. So take advantage of it. Both ask the questions, and then when someone else poses a question, respond. So going back to me, I been a closet writer forever. Finished a novel a few years ago and decided to self-publish it. That was Coyote Wins. That's when I decided, I also, as a lawyer for 30 years, there was a way I could help writers with the self-published legal handbook. As I mentioned earlier, I just released the second edition today, which covers everything the first edition did, plus a few others. So everybody, please go out there, write, publish, prosper, and be part of this great community. So that wraps up my formal part, and I can take some more questions.
That was a great presentation, Helen. Thank you so much. We have one comment from Rosemary Letson. She said, oh my God, I just received an invite from a company to present my books at an international book fair. This was very timely. I planned to say no thanks, but the timing is uncanny.
Yeah, once you get on those mailing lists, you're going to get lots of those. And some of them, don't assume, I think there's 2 or 3% of them that are actually worthwhile, but you just have to be careful.
Yeah, absolutely. Well, I think that those are all the questions we have. People have really hung on after signing in,
Okay.
so they really liked your presentation, and I thought it was fabulous. This is going to go on my blog, but until it does that, I will send a replay of this to everyone who signed up and everyone who attended. So you'll be able to listen to Helen again in case you had any questions or confusion about what she was saying.
Yeah, I covered a lot of the material, so let it digest. And again, people can send me questions, or if they want the slides, just let me know.
Great. Thank you so much, Helen. I really appreciate your time.
You're welcome. Take care.
And I appreciate the time of everyone else who attended. Thanks so much for signing up for this webinar, and hopefully I'll see you next month. Thanks.